Thank you, Acting Chair. Councillor Badaway. Councillor Bateman.
Present.
Councillor Campion. Councillor Kiokio. Councillor Crater.
Present.
Councillor Diodati.
I'm here.
Councillor Easton. Present. Councillor Foster.
Present.
Councillor Gannan. Present. Councillor Greenwood.
Present.
Councillor Height. Present. Councillor Encina.
Present.
Councillor Yip. Councillor Jordan. Councillor Junkin.
Here.
Councillor Kaiser.
Present.
Councillor Morocco.
I'm here.
Councillor Olson.
Present.
Councillor Redicott.
Here.
Councillor Rigby.
Pleased to be here.
Councillor Seaborn.
Present.
Councillor Secord. Councillor Cisco. Councillor Sorrento.
Always a pleasure, Clerk. Thank you.
Councillor Steele.
I'm here.
Councillor Ugolini. Councillor Villela.
Present.
Councillor Whalen.
Present.
Councillor Zalepa.
I'm here, thank you.
And we have regrets from Councillor Whalen.
Madam Clerk, this is Councillor Kiokio. I'm present.
Thank you.
Okay, thank you. So at this time, I'll call on Councillor Gannan to read the land acknowledgement statement.
Thank you, Chair. Niagara Region is situated on treaty land. This land is steeped in the rich history of the First Nations, such as the Hattaway-Wendourong, the Haudenosaunee, and the Anishinaabe, including the Mississaugas of the Credit First Nation. There are many First Nation, Métis, and Inuit from across Turtle Island that live and work in Niagara today. The Regional Municipality of Niagara stands with all Indigenous peoples, past and present, in promoting the wise stewardship of the lands on which we live.
Thank you, Councillor. So we'll move into the adoption of the agenda. Is there a mover and seconder to adopt the agenda? Please vote electronically. Oh, sorry. Mover and seconder. Councillor Seaborn, Councillor Greenwood. Now I'll ask if you vote electronically. All right, so that is carried. Moving on to disclosures of pecuniary interests. Are there any disclosures of pecuniary interests this afternoon? Seeing none. Okay, with that, this meeting is being held to conduct a statutory public hearing to deal with the development charge complaint filed with the clerk under Section 20 of the Development Charges Act 1997. I want to remind Council of the importance of having reviewed the complaint and corresponding staff report prior to consideration of the complaint. This is a reminder that our discussions, presentations, and questions must be conducted through the chair and done so in a respectful manner, and I thank you in advance for your cooperation. I will further remind Council that this is a hearing. The 10-minute time limit does not apply. I will now call on Roman Ivanov, Niagara Region Legal Counsel, to provide an overview of the procedure for the hearing.
Thank you, Chair. Through the chair, through you, I would like to provide a few procedural remarks before the hearing. Just to remind you that this matter is being heard pursuant to the Development Charges Act. In this context, Council is not sitting as a policy-making body. Instead, it's exercising a statutory power of decision. As a result, Council is acting in a quasi-judicial capacity, and the hearing is governed procedurally by the Statutory Powers Procedure Act. Now, Council's authority in this proceeding is limited by the Development Charges Act. Specifically, under Section 20 of the Development Charges Act, its authority in the context of a development charges complaint is limited to the following circumstances. A, the amount of the development charge was incorrectly determined. B, a credit available to be used against the development charge, or the amount of the credit or the service with respect to which the credit was given was incorrectly determined, or lastly, there was an error in the application of the development charge bylaw. Council is not reconsidering the underlying development charge policy or exercising general discretion in this hearing. Rather, Council's jurisdiction is confined to determining whether the development charge was imposed in accordance with the Act, including whether there has been an error in its calculation or application of the Act as permitted by the legislation. Council has a copy of the complaint as submitted, and you can find it attached as Appendix 1 to staff report, as well as a copy of the supplementary presentation materials provided by counsel for the complainant. Legal counsel for the complainant is present today and will be given an opportunity to make submissions with respect to the complaint. Staff report provides the recommendations of staff in response to the complaint, and staff is supported by external legal counsel retained by the region, Ms. Piper Morley, who is also in attendance today. Council will have the opportunity to ask questions of both the complainant and their representative, as well as of staff and Ms. Morley. After hearing the evidence and submissions of the complainant, council may dismiss the complaint or rectify any incorrect determination or error that was the subject of the complaint. Once council has rendered a decision pursuant to the Development Charges Act, notice of regional council's decision is required to be mailed to the complainant by the clerk within 20 days. The complainant may then appeal the decision of council to the Ontario Land Tribunal. The last day to appeal the decision is 40 days after the day the decision is made. Thank you.
All right, thank you. So as the staff report provides the materials related to the complaint, is there a mover and seconder to put the staff report on the floor prior to hearing from both parties? Councilor Morocco, Councilor Olson, thank you. Okay, with that, I'll call on Piper Morley, external legal counsel for the region, to provide an overview of the complaint.
So good afternoon to the chair and members of council. It's very nice to meet those of you that I haven't met before. I'm Piper Morley. I represent regional municipalities in the GTA, as well as local municipalities and developers in the city of Toronto. So in front of you today, you have a development charge complaint under Section 20 of the Development Charges Act. And you're going to be making a determination on whether the region has correctly calculated the development charges payable for the proposed development at 3770 Montrose Road. Under Section 20, Council's jurisdiction is narrow and quite well defined. You're not being asked to make a policy decision or to balance competing objectives. The question before you is really a legal one. Has there been an error in the calculation of the development charges or in the application of the Act or the region's DC bylaw? If the answer is yes, Council may direct a recalculation. If the answer is no, the complaint must be dismissed. So as set out in the staff report, there has been no error in the calculation or the legal interpretation, and the complaint should be dismissed. The complaint is not about getting shovels in the ground. It's not about encouraging development. It's about extending a benefit that was intended to get housing starts within 24 months from ZBA to a situation where we're well past 45 months with no building permit application. But more than that, it's about setting a precedent and fairness to other developers who have followed the correct exceptions in the Act. This case turns on a single legal issue. Does a demolition permit constitute a building permit for the purpose of maintaining a development charge rate freeze under Section 26.2 of the Act? That was a lot, so I'm just going to walk you through exactly what that entails, okay? The complainant says, yes, it does, and they're relying on the wording of the Building Code Act, so not the Development Charges Act, the Building Code Act, and an OLT case, which I'll talk to you a little bit about. The region says no, and that's based on the text of the Development Charges Act itself, the structure of the statutory scheme, and the clear legislative purpose of the rate freeze provisions. I'm also going to throw in there that the case itself, from my perspective, actually supports the region's position in this. So I'm going to walk you through a little bit of the framework of the Development Charges Act because I think it is quite helpful in understanding that before we get into the positions. The DCA establishes a very clear series of events. First, a development application is filed. Second, a potential rate freeze is triggered. Third, a building permit for construction is then issued. And fourth, the development charges are then calculated and payable. The rate freeze under 26.2, which allows people to rely on an earlier version of the zoning or of the DC, it's not automatic and it is not indefinite. It is expressly conditional in this act. There are two requirements that have to be met. The first is there has to be a qualifying application. There's no debate here. There was a qualifying application. It's zoning bylaw amendment. They made that application in January of 2022. So that's when they would be locking in those rates. The second thing is that a building permit must be issued within the prescribed time frame. And if a building permit is issued in the prescribed time frame, and I'll talk to you a little bit about what that prescribed time frame is, because at first it was 24 months and the Ford government updated it to decrease the time to pull building permit because they wanted to encourage housing starts to 18 months, then you can rely on the freeze. So in this case, the ZBA, I'm just going to walk you through some of the chronology so that you've got it in the back of your head. I know it's in the staff report, but for clarity, ZBA was approved August 9th, 2022. The 24-month time period expired on August 9th, 2024. No building permit for construction was issued within that time period, and only demolition permits were issued, and they were issued in December of 2022. That's the crux of the issue here. Does the demolition permit meet the requirement under the Act? And the legal question is whether that demolition permit satisfies this requirement. Does it trigger it? The Act does not define building permit, but the staff report correctly applies modern statutory interpretation. Words must be read in their entire context harmoniously with the scheme and purpose of the Act. In that context, building permit must mean a permit authorizing development, not removal. This is for a couple of reasons. A building permit triggers development charge liability because it relates to construction, gross floor area, and intensification. A demolition permit does not authorize any of those things. This is not just semantics, it's actually a functional distinction which is embedded within this legislation. A building permit for construction authorizes new growth, which is what the DC Act is trying to get at, new growth. A demolition permit simply eliminates existing structures. Only one of those generates the need for infrastructure funding, and accordingly, only one of those can logically trigger the financial mechanisms under the DCA. The Regent's interpretation is reinforced by how the Act operates as a whole. I'm just going to walk you through Section 26 very quickly. Development charges are calculated and payable at the building permit stage under Section 26. This presupposes that the nature of the development is known. The density, the unit mix are confirmed. This is how DCs are calculated. The gross floor area can be measured. None of that exists at the demolition stage. As staff correctly note, at the time of demolition, key inputs required to calculate charges often don't exist. That alone demonstrates that the complainant's interpretation is simply incompatible with the legislation itself. So I'm going to talk to you a little bit about the purpose of the rate freeze regime, because that also gets to a little bit of the heart of this. The rate freeze provisions were introduced by the Ford government to provide certainty about rates in the short term to developers and encourage housing delivery, not land banking, not delay. The rate freeze allows developers to lock in the DC rate at the rate that was applicable when the zoning bylaw application was made. And as I said to you earlier, that was in 2022, January 2022. The freeze provides cost certainty at a defined point of commitment to construction, That commitment is evidenced by a building permit. The province has reinforced this direction through Bill 108, which introduced the freeze, and through Bill 185, which actually shortened the freeze period from 24 months to 18 months in order to accelerate construction timelines. They wanted shovels in ground. It was very clear in the Hansard and in the debates. This shows the legislature's concern is timely transition from approval, ZBA approval, to the time period of construction itself. It is not concerned about preserving historical rates indefinitely. This complaint, I submit, is not about getting shovels in the ground and incentivizing development. That's already been done. That's what the incentive was created for in the first place. To be clear, there has been no application for building permit to this very day. This is about whether the developer gets to freeze 2022 rates, even though they did not technically meet the statutory requirement that every other developer has been required to meet. And again, we're at 45 months from zoning application, nearly 4 years. The complainant's interpretation also produces some absurd results. The staff report does address this, but I do think it's important to emphasize this for council's purposes. If demolition permits triggered the rate freeze, the rates could be locked in without building. Developers could obtain a demolition permit, clear a site, and delay construction indefinitely. That would convert the rate freeze into an open-ended entitlement. The Act expressly doesn't permit that, and it certainly was not the intention of the rate freeze provisions that were introduced by the Ford government. And also, development charges simply could not be calculated. I said this before. Density not known, unit mix not known, GFA not finalized at the demolition stage. You simply cannot assess development charges in that context. There's also a practical concern that has something of a precedential basis. A demolition permit could be used as a financial tool to hedge against future rate increases by developers if you accepted this interpretation. That's entirely inconsistent with the purpose of the legislation from my perspective. It also undermines the growth funding model. If outdated rates are applied, infrastructure costs are not fully recovered, the shortfall is likely shifted to the existing taxpayer. And this undermines the core principle that growth pays for growth. So I'm going to take some time now to respond to some of the complainant's legal arguments because I understand that's the nature of how you folks do your hearings in this case. The complainant relies heavily on the fact that both construction and demolition permits are issued under the same section of the Act. We don't deny that. They're both issued under Section 8 of the Building Code Act. That doesn't resolve the issue here. The question is not how the BCA categorizes permits under a particular section, but how the DCA uses the term building permit in its own statutory context. The same word can have different meanings in different statutes, particularly where the purposes differ. I am going to try to use this. Let's find out. There we are. Okay. So the complainant cites the Upper Wellington case, and I want to take a bit of time. I'm not inclined to go through chapter and verse of case law with you folks. I am not inclined to do that. That being said, I do want to address one aspect of that case, okay? In our submissions, this case is explicitly not helpful to this complainant. The case dealt with parkland dedication under the Planning Act. It did not interpret the Development Charges Act. It addressed a different statutory trigger and purpose altogether, and the reasoning simply cannot be imported into the DCA framework. But even if you accept that this is something that we should look at for the purposes of making a determination today, again, this was about a transition provision in parkland dedication section of the Planning Act. The result would still be that council would actually still need to reject demolition permit as the appropriate trigger. And the reason why is actually set out in paragraph 49. So in that case, the words that they were relying on, so the portion of the act, the transition provisions in the parkland dedication section, says in respect of development, okay? And so what the tribunal says is the tribunal agrees with City Council that the words in respect of, when read in their grammatical and ordinary sense in the context of these provisions of the act, mean that the permit in question need only in some way relate to the redevelopment, right? It only has to somewhere along the line relate to the redevelopment, that permit. But then they draw this distinction. This is as opposed to for a development or redevelopment, which may imply or require a more linear relationship, as the applicant's counsel has argued. So what they're saying there is that the words in respect of, which is in the Planning Act, that is not the same thing as for a development. For a development is a direct linear relationship. You are pulling building permit. Then they go on. They say, moreover, in reference to the applications for demolition permits, the tribunal notes that the permits are titled building permit. And then they actually show a picture of the, I saved you from this, show a picture of it in the case itself. And so I think it's important for us to look at this a bit. Again, I'm just doing the comparison for you. It's for the development in the case of the expiry of the rate. It is in respect of the development in the case of the Planning Act. These are the demolition permits that were issued in this case, okay? So what they were saying is, in that case, they were looking at the actual building permit itself. The title was building permit. Underneath it, it referenced a site plan. It was clearly done in the context of the development. What we have here, and I'm so sorry for those of you who have to lean in really close, are 2 demolition permits. And they are issued that way. They are issued as demolition permits. You probably can't see this, but it says description demolition, and then it says demolition strip plaza, demolition retail store. All of the language surrounding it is about demolition. Absolutely none of this relates in any way, shape, or form to a redevelopment of these lands. They're standalone building permits. Okay. I'm actually done with this slide altogether, I think. The complainant also notes that the city of Niagara Falls accepted this interpretation, which they did. The fact that the city made this determination is not relevant to the determination to be made in front of you right now. Council's obligation is to apply the region's bylaw consistently with the DCA. So with respect to the expiry of the freeze, applying the correct interpretation here, the ZBA was approved August 9th, 2022. The 24-month window expired August 9th, 2024. No construction permit was issued during that time period, therefore the freeze lapses. Development charges are payable at rates in effect at the time of building permit for construction, and this is exactly what the region has done in this case. I'm going to talk to you quickly about fairness and equity. This is an important dimension to this. Other developers, in this case, obtained building permits within the statutory timeframe and satisfied the conditions of the act, and they've benefited from this freeze. Then there's the flip side. You have developers who got their ZBA approved but missed the window for whatever reason for pulling building permit, and they paid their DCs in accordance with the current rates. That's how that's gone in every other situation here. Granting this could effectively create an exception and a partial exemption to a tax. They're going to get the same benefit without meeting the statutory conditions. This would undermine consistency and fairness in the administration of this act. It would also bluntly represent an abrupt change in how staff processes applications in the region. If you accept the complainant's position, this is setting a new and significant precedent, generally where building permit is triggered. Substantial cash flowing impacts could occur, and there would be uncertainty for developers in the market. So council's task is focused, determine if there was an error here. There was not. A demolition permit is not a building permit for the purposes of the Development Charges Act. The complainant did not meet the statutory condition for maintaining the rate freeze, and the freeze expired in August of 2024. The region correctly applied current rates. The calculation is legally and factually sound. Accordingly, we would request that council dismiss the complaint in full. And subject to any questions, those are my submissions to you.
All right, thank you. Are there any questions for external legal counsel or staff related to the report? Okay, first we have Councilor Campion.
Yeah, thank you. Thank you for your presentation. Question is not contained in your presentations, but I'm going to ask the question. If you don't wish to answer, that's fine. What is the City of Niagara Falls' position on this matter? I can ask the question at another point in time if it's.
It may be better to speak about that in camera than in an open session.
Okay. I'll turn it over to Associate Director Chen to speak to that.
Through the chair to the councillor, so City of Niagara Falls staff has informed regional staff that they are planning to consider the demolition credit as the building permit for this specific development, and therefore they are going to offer rate freeze.
So, through the chair, put that plainly, they're supporting the 2022 rate, is that correct?
Through the chair, that's correct.
Thank you.
Nothing further, Councilor Campion? No. Okay. Then we will move on to Councilor Bateman. You'd like to withdraw? Okay. Then we'll move on to Councilor Easton.
Thank you very much, Mr. Chairman. Thank you for the presentation. I reviewed this document with the Town of Lincoln staff, since those are the people that were available to me, because I also wanted to see how another municipality would consider this. So a couple of the questions that we were discussing comes under this application for permit to construct or demolish, which is the wording that is used on our local form. You're saying that the demo permit is not a building permit under the DC Act. Is it appropriate for the region to make that legal differentiation in light of the fact that you don't issue that document? But it occurs at the local level. And so what jurisdiction would you have over any interpretation of what they do?
Right. So just to be clear about the presentation and what I was just referring to with respect to the Building Code Act, a demolition permit is issued under Section 8, as is a building permit. They are both issued under Section 8 of the Building Code Act. There's no debate about that. They're very clearly issued under the same thing. The question is an interpretation question under the Development Charges Act. So the region and the local municipalities, obviously, they both levy development charges, and the interpretation is a requirement for both of them. So in this case, essentially what we're saying is, if you look at the actual demolition permits that were issued, these were standalone demolition permits, right? These were not in respect of they weren't in respect of a development in any event, but even if they were in respect of a development, that's not the language of the Act. It's for development, and the tribunal was very clear that for development is intended to be a close-knit linear relationship, not something along the way like a demo permit.
Okay, then, and so do you have any knowledge of how that differentiation was presented to the developer as separate entities, or whether it was or not at all? In your investigation, did you find that out?
So what I have in front of me are the demolition permits that were actually issued to the developer here. These are the actual demolition permits. And you'll note they are titled demolition permit, They are most certainly issued under Section 8 because they have to be under Section 8 of the BCA. And they specifically speak to demolition strip plaza and demolition retail store.
Okay, and so having said that, what does the conversation that takes place between planners and chief building officials have any on the matter of proposed future work as part of the pre-con, for example? Would that have any bearing on what you investigated on this matter? Because I realize what's here. I haven't seen this before. We haven't seen this before, so I don't really know what it says particularly under notice. I can barely read that. But what I want to know is, what conversations took place during that pre-con. It seems a little bit sketchy to me that it wouldn't have come out at some point that there was going to be future work done on this land.
So what I'm saying is not that there wouldn't be future work that was done on the land or known at the time that, if there was a development application that was coming forward. Of course, that development application was coming forward. What I'm saying is that as a matter of legal principle, because it's for development, that language is clearly indicating a tight linear relationship, that it would be building permit and not demolition permit that would trigger the end to the rate freeze.
Okay, and is it your belief, through you, Mr. Chair, that this is exactly how this would be interpreted by other legal experts across the province? Could we expect to see that interpretation consistently across the province?
You actually have seen that interpretation across the province, and how that's done is under Section 26. You do not see any municipalities whatsoever attempting to charge development charges at the time of demolition permit. And it's the very same language. It's for the development. Not a single municipality does that.
Okay.
Yeah.
Just let me have a quick look here to make sure that, so you didn't really answer my question about the pre-con discussions and whether or not there would have been any intention expressed at that time.
Councillor Hussein, I think we can turn it over to the Associate Director. She might have a better answer for you.
Through the chair to Councillor, my understanding is there was pre-consultation specifically around the development charges implications for this development. So city staff engaged with regional staff back in October 2025, so last fall, to inform that there's ongoing discussion between the city staff and the complainant. And at that time, we were informed that the city has decided to accept the complainant's legal opinion that they received, and they would consider a demolition credit as a building permit. And then since that time, regional staff have started our internal review and discussion with our DC consultant, our legal counsel, both internally, externally. We also reached out to our municipal peers and to see whether they have taken a similar approach, and we have made sure that none of the municipalities has considered demolition permit as a building permit under the DC Act, specifically for rate freeze provisions. And then after that, we had confirmed with the complainant that the region's taking a different position compared to the city, that we will be applying the current rate for this development.
Okay, so, Mr. Chairman, what we haven't talked about, and if your plan is to talk about this a little bit later in the dissertation, is it possible that we would find ourselves in a situation where, and we do this, it's not totally uncommon, but if the region's position was firm and the municipality's position is firm, then what is the process? Is this the only process that will determine what action would be taken? For example, if this body does not support the region's position, then does that is there any mechanism for the money to be collected? It's not going to be collected through the city, but what other mechanism is there for the money to be collected by the region? Does such a thing exist?
Turn it over to the Associate Director again.
Through the chair to the councillor, so we work with the city closely to share the region's position in terms of DC, regional DC amount owing. And as per the DC Act, the local area municipalities are responsible to collect regional DCs. So I guess my answer to you is the city or the local area municipalities would be collecting based on the direction that from the region, from staff or regional council or decision from tonight. There's no other mechanism or standard mechanism to collect regional DCs other than through the local area municipalities.
Okay, Mr. Chairman, there's no authority, there's no hierarchy of authority there, so I don't know, it doesn't sound like there's a way to collect this.
So just to clarify through the chair, so Councillor, you're asking about the applicable regional development charges collection for this development?
That's correct.
Who is to collect? So we have shared the estimated regional development charges with the city, and again, as Piper alluded to, the complainant hasn't applied for a building permit. Therefore, there's uncertainty with the specific of the development, so which we're not able to confirm the DCs payable. But I guess in practice, the local area municipalities will be collecting DCs in discussion with regional staff. I don't see the reason why they wouldn't be collecting the regional DCs for this particular development.
Then why are we here? I mean, Mr. Chairman, why are we having this discussion? If the city is not going to collect the DCs on behalf of the region, if that's not going to happen, then why are we having this discussion?
Go ahead.
So the chair, I'm sorry for the confusion. Just to clarify, the city will be collecting regional development charges on our behalf.
I'm not satisfied that that will take place. If they disagree now, they will collect their own DC charges, but why are they going to, what's going to motivate them to collect on behalf of the region?
I guess the discrepancy is their DC treatment versus regions DC treatment. We're still responsible to calculate the regional DCs. It's just the body or the entity who's collecting the payment is through the local municipality because they have the building planning authorities. So it's a flow through. But ultimately, regional council, regional staff, we have the authority to administer the region's DC program and collect these regional DCs.
Okay, I won't belabor that, Mr. Chairman. However, I think that question is going to have to be answered after the decision is made tonight. Thank you. Thank you very much.
Thank you.
That's all, Councillor Easton? Okay, we'll move to Councillor Villela.
Oh, thank you. Through you, Mr. Chair. I just have a couple questions, if I may. Can you tell me if the Act expressly, or I should put in terms, the Act does not expressly state a demolition permit shall not constitute a building permit? Does it expressly state that?
It does not, no.
Okay, it doesn't. So this may come down to procedural fairness at the end of the day. I have another question for you, if I may. Would you agree or disagree, I guess, that the demolition permit was obtained for the specific purpose of facilitating the approved residential development?
That's right. It could very well facilitate the residential development in the longer term. The issue is that the language of the act requires that its first building permit is issued for the development, and the interpretation of that has really meant tight. It's meant building permit, rather than in respect of, which I believe you're referring to. That type of language, in respect of, for the purpose of, that type of language is really intending to get at somewhere along the line of redevelopment. It would facilitate in it. That's not what the act requires us to look at. And it's also doesn't really match the legislative intent.
So it may be fair to say then that the applicant, I guess in this case, may be raising an arguable, question regarding, I think, statutory interpretation. I think that this is what it's probably gonna come down to. So, and we seem to fall into this situation more times than not, and that's unfortunate when it comes to our DC bylaw. Okay, thank you very much. I appreciate you answering my questions.
Thank you.
Thank you, Councilor Villela. We'll now turn to Councilor Morocco.
Thank you, Chair. Thank you very much for your presentation. I greatly appreciate that, Ms. Morley. A question I have is that the first part of the presentation, you said that actually the game kind of changed after the application for the demolition was granted. So there was some changes that happened in regards to timelines that the province set down?
That's correct.
Okay. So I would assume that the developer really didn't have that in the game plan when they started out, that there was going to be changes implemented by the province.
So we don't actually rely on those changes, like the Ford government shrinking the time period. We've actually just fully accepted the 24 months because they are entitled to that 24 months under the Act. So we're still applying the larger time period in coming to that conclusion because they would have run out of time under that larger time period in August of 2024.
Did the applicant, did they have any issues that came up along the way that might have delayed them with the demolition moving forward to get the permit for the building? Through the chair? To staff or to whoever?
Okay, once again, Associate Director Jen.
Through the chair, staff are not aware of the specific reason why there was a delay between the demolition and the development.
Okay. And I just want to go back, thank you so much, and I just want to go back to the chair. I'm not too sure who can answer this, but it seems to be that it doesn't matter who applies or grants the permit and the development charges actually who collects that. I mean, at the end of the day, whatever city gives a permit, the development charges are collected and then dispersed to the region because they're actually used for what? I guess I can ask staff through the chair. Can you tell me what the development charges would be used for?
Associate Director, once again.
Through the chair, so development charges are collected by municipalities whose council has imposed the development charges bylaw. And the purpose of the DC funding is to support future growth projects. So in this context, I guess municipalities are playing an equally important role as developers in terms of building new development, supporting growth, and building new housing in the communities. So the developers will building the actual housing, and municipality are supporting the associated infrastructure, water, wastewater, roads, police stations, long-term care homes. So for Niagara region, our DC funding requirement is driven by the future growth projects. So just to provide a little bit of a context, so for next 10 years, our total DC funding requirement is approximately $2.14 billion. So those are included in the region's 10-year capital forecast, and that's the funding requirement. So I guess I can give a couple of specific examples. For example, 2025, the council approved capital budget There was a significant capital budget or capital project related to roads improvement in Port Colborne for the new or a water main improvement in Port Colborne at the new Barrack Road. So that project is, predominantly growth related, and the DC requirement is around $25 million to support that water main project. So all the development charges funding that the region collects will be supporting those growth-related projects, including the water main in Port Colborne.
Great. So the next question, I appreciate that. So the next question is that we are not looking to not charge development fees. We're actually looking to reduce and actually offer them the rate that when they actually took the demolition permit out, that's what they're looking for, because that's what they were anticipating that they would be paying at that time of taking a demolition. I'm assuming, I'm just going to say, through the chair, that if the council of the day was sitting there and they're actually talking to a developer that's coming to get a demolition permit, I'm sure that they're looking to build something on that piece of land. So, with that application being said, that they're looking to say, okay, I'm expecting that this is the rate that I'm going to pay. I'd have to deal with this demolition. I'll go back to 2022, is because I know I've worked with some developers in the past, and they've had some major challenges with either supplies, equipment, staffing, and whatever. And I'm not sure that that's exactly what's happening here, but I think that there's situations that might have to look at a little bit deeper and consider. But I guess my question I'm getting to is, how many of these are on the table right now that we'll have to look at? Through the chair.
Not sure that I could answer the question about how many of these specifically that are kind of coming down the pipeline, Councillor Morocco. I don't think I could speak to that all.
Associate Director Chen has the information, so.
Through the chair to the councilors, the staff did do some review and look at the historic data. So in terms of developments involved demolition of existing building, based on our records from 2024, 2025, and 2026 year to date, there's about 27 developments that we collect the development charges for that involved demolishing an existing building in order to build a new building. And in terms of dollar amount, because we do provide a demolition DC credit, should the at the time of building permit application is within 5 years of the demolition, we provide a credit. So dollar-wise, there's approximately $2 million that the region has provided as a credit to these 27 developments from 24, 25, and 26 year to date.
Okay.
I hope that helps.
And through the chair to staff. So that's not dating back as to 2022. This is started at 2022, is that correct? This one in particular? Okay. Staff are saying yes, okay.
The zoning bylaw approval, that application was submitted in 2022. The demolition permits were issued at end of 2022. So I would assume the actual demolition happened end of 2022, early 2023.
And I'm not too sure, but just to give I'm not looking to actually give away anything free. There's nobody that knows anything more than all of us sitting here about the water and wastewater in our situation. But I'm sure that it's not one developer that's going to pay up all of that. We're in the situation of $2.7 billion in infrastructure. At the same time, I think that it's like anything that comes across, we have to look at it and look at what's fair. So I think this is a situation that I'm not too sure that they might have had some issues along that way in 2022 with a lot of the other developers and builders, but that's all. Thank you.
All right. Thank you, Councilor Morocco. We'll go to Councilor Encina.
Thank you, Chair, and thank you for the presentation. I'm hoping you're going to help me work through this. So on December 8th on 2022. The time frame starts for how many months? 24 months?
So it's actually for the zoning bylaw application. And so when they received approval, it was August 9th, 2022.
Right.
And the 24 months starts from that point. So it would have expired on August 9th, 2024.
Right. Now, if they're going to think that the demolition permit is a building permit, what regulations, is it the same time frame of 24 months?
That's right. The 24 months would just apply from zoning bylaw.
Right.
So essentially, they were able to pull permit on December 8th, 2022.
Right.
And so both of these demolition permits were issued at that time, so they're well within the time period. That's why they're relying on the demolition permit as the trigger.
See, because I don't through you, Chair. I'm looking at it. You have 24 months to deal with it. That brings you to 2024. We are now into 2026. I have a real issue with this. So now you're going to want us to say, okay, well, we had a demolition permit and we thought. Well, what did you think 2 years ago? Why didn't you bring this up 2 years ago? And now you waited till now, so now you're going to bring in a permit and ask for the rates down in 2022. When in fact, everything has gone up how many? 30%, 40%? So who gets stuck with that? You and I? Because they didn't want to do that? What kind of Pandora's box are we going to open if we say the demolition permit is accepted as a construction permit? What's any idea what the hell is going to happen?
So there is precedential impact here that
absolutely.
is going to occur, right?
Absolutely.
This has not, to my knowledge, and I do represent a fair number of regional and local municipalities, this has not, to my knowledge, been done by any municipality to date. And that includes some that have gone through great lengths to try to figure out whether or not certain things can be done to incentivize development outside of the DCA and trying to make sure that we're not running offside bonusing provisions under the Municipal Act, et cetera, right? Not benefiting an individual. So this is something that is highly focused on. I'm not aware of any municipalities who are taking this position that a demolition permit could lock in. The concern is obviously that would essentially lock them in. It could continue on indefinitely. At that point, is it really kind of upholding what the Ford government was attempting to do by implementing the freeze in the first place? You know, development's not, there's no shovels going in the ground. Development is not occurring. It was intended to incentivize, not to lock in a rate indefinitely.
So I would suggest to you, through you, Chair, then because June 1st could come around this year and say, oh, we're not going to build this year because we've got this locked in. Because in essence, that's what they're asking for, right? They've already gone past the 24 months. So what's to stop anything from going on for the next 2 years before doing anything? Is there anything that's going to stop that?
I don't believe there is.
That's what I'm saying. So you talk about sitting on a piece of land. Why not? Because if it ends up to be 2030, and then we're expected to go back to 2022 rates, potentially that's what could happen, could it not? If you're looking at it that way.
Correct. It could continue on indefinitely.
Absolutely. So I think we really have to look at this, and this is precedent setting, ladies and gentlemen, like councillors. I'm sorry, it's spelled out. Even the time frame doesn't match. So I'll leave my comments to there. Thank you very much for your time.
Thank you.
Thank you, Councillor Encino. Now move to Councillor Bateman.
Thank you, Chair. Thank you very much for your presentation. To be clear, you're talking about DCs that are part of the Municipal Act. Is that correct?
No. Development charges
zoning law.
under the Development Charges Act.
Oh, Development Charges Act, sorry, my apologies. And the Development Charges Act is an act that is province-wide?
Yes, it is.
Okay. So knowing this developer and knowing that they have many developments going on, they should be aware of these timelines as it would apply to all of their prospective builds.
It's set out in the legislation.
Perfect,
Yes.
thank you. Through you, Chair. So the developer would likely know, and the onus is on the developer to follow the municipal act, or the DC Act.
That's right. And in fairness to them, their position is one of interpretation, right? They're just saying a development, like that a building permit itself, that could be construed as being a demolition permit. And our response to that is not under the clear meaning of the act, not under what was intended by the changes to the legislation through the freeze, and also, not pursuant to the very case that they rely on.
Thank you. So to your point, I thought I was done, but just to be clear through you, Chair, there is a demolition permit and there is a building permit.
Permits. Right, that's right.
Okay, that's it. Thank you, Chair.
Thank you, Councillor Bateman. We'll now move to Councillor Diodati.
Thank you. Thank you, Chair. Can you hear me okay?
Yeah, we can hear you fine. Thank you.
Great, thank you. So thank you for the presentation. Couple questions for you. One question, do you believe that a demolition permit is part of the building permit process? Through you, Chair.
Thank you so much. So it is under the very same section of the Building Code Act. A demolition permit and a building permit are under Section 8 of the Building Code Act. That's not in debate here, right? Like what is in debate is whether or not through the Development Charges Act, what's
No, I understand. I understand the debate. Thank you. I just want to be clear that you agree with me that a demolition permit is part of the building permit process.
Yeah, pursuant to the case that we have up on the screen here.
It's yes or no.
It is in respect of the development, a demolition permit, which is what the
So it is a
OLC
part of it then.
It is
Okay,
in respect
so-
of it, yes.
Okay, so I just want to be clear that it is a part of it. My next question, through you, Chair. You made a comment earlier, I'll paraphrase, that a building permit demonstrates commitment. So I'm just wondering what you mean by that, through you, Chair.
A building permit means that you've pulled building permit, you're likely paying some portion of your development charges at that point, and you're likely getting shovels in the ground very quickly from that point.
Okay, what happens if you don't build, through you, Chair?
If you don't build, I suppose your building permit could expire, depending on whether or not that's set out in the building permit itself. It could expire. But in all likelihood, you've paid some amount into it in order to get the building permit. So in all likelihood, you are going to be developing quite quickly, which I think is what the intention of the act was.
So what happens, as I understand it, is your building permit expires and you forfeit your fees. You lose the money. That's what happens. So my next question through you, Chair, who is the building permit issuing authority?
The local municipality, the CBO of the local municipality, the chief building
Right.
official.
Right. So the region does not issue building permits.
No.
Okay. So in this case, if I understand correctly, the applicant would have went to the municipality, in this case, City of Niagara Falls, and they would have obtained DC certainty. That would have been needed at the local level because it's the local level who issues the permits. And based on that information, would have made a decision to bring the site to market. Is that right?
As I understand it, through my conversations with staff, what occurred was that at the local level, staff there informed them that they should go speak to regional staff about their position on this, which they then did. And that's actually set out very clearly in the complaint itself.
Okay, but I think we can agree that it's the city who issues the building permit. They are the authority on this issue. Is that right?
The chief building official of the city issues the building.
Right. That's the municipality, correct. Right. So my next question through you, Chair. Was demolition required to make this site able to proceed for development? Was it necessary before we could do a build?
I understand that in this case it is, and that would fall under the in respect of, which is set out by the tribunal in the Upper Wellington case. The demolition in that case was also required in order to build it out, and that is in respect of. It is not for the development.
Right. But if it wasn't demolished, we would have a Canadian Tire building, 85,000 square foot building, and a mall and a parking lot sitting there. So how would they be able to move forward with the development if that was still sitting there? How could you do that otherwise? Is there any other way other than demolishing it first?
I'm sure in this case it was required in order to get at some point to development. What we're getting at here is that there is a difference between demolition permit, which is in respect of the redevelopment, and building permit, which is required for the development.
No, I understand. I'm trying to stay on topic here. So my next question through you, Chair, is, are you aware that they were, while they were doing the demolition, putting in services, underground, building roads, and everything that's been done under the ground so that they could build the housing and the rentals will be completed in June. So they've been building the services and the infrastructure. Are you aware that that's been taking place through your chair?
Yes, we're aware that that's been taking place. That's not relevant to the statutory interpretation question that's in front of this council.
Oh, I think it is. I think it's very relevant. And through your chair, the development, and I'm glad you pointed that out, the Development Charge Act, the DCA, does not define building permit under the OBCA. Is that right? It doesn't define it. Is that right?
Yes, I did mention that at the beginning of my presentation.
You did. So I just wanted to be clear. So a building permit and a demolition permit are treated the same. They're issued under the same section, Section 8. Is that right?
They're not treated the same. They come out of Section 8 of the Building Code Act. Both
They're
are
not treated the
issued
same?
pursuant to Section 8 of the Building Code Act.
Okay, but they're not treated the same?
I'm not sure what you mean by treated the same, but in this case, what we have are, instead of
Do they
building permit,
differentiate
we
between
have
them?
demolition permit, and then you have building permit for the purposes of the development. In this case, just a standalone demolition permits were issued.
So what I'm asking is, do they differentiate between them? Through you, Chair.
I'm sorry, I'm not trying to be obtuse. I really don't understand the question. Who differentiate between them? Does the act?
Does the act? Yes, the DCA.
Councillor, Associate Director Chen has an answer for us.
Through the chair to the councillor, so we're here today to discuss a development charges complaint under the Development Charges Act. So under the DC Act, the act does reference other types of permits, building permits throughout the act, the legislation. For example, in some places, it does reference permit of occupancy. And specifically under the rate freeze section, it references building permit, which if you read the legislation, I guess in full context, and the building permit under the reference under the rate freeze section would be referring to a building permit that would authorize construction, alteration, redevelopment, or occupancy. So those types of building permits will be qualified or meeting the definition of building permit. And to answer your earlier question, in some cases, demolition would result in redevelopment, but that's not always the case. So what staff can do is to make sure that we apply the DC Act and our bylaw consistently based on our understanding of the legislative intent, and make sure that we provide DC treatment consistently and fairly to all the developments in the region of Niagara. So we don't have authority to choose to offer or consider certain permit as whether they're building permit or not for certain developments. We don't have authority to do that.
Okay, thank you, Chair.
Thank you, Councilor Diodati. So with that, we'll go to Councilor Height.
We have the building demolition permit in front of us. As I'm reading this, we're demolishing some buildings, but it doesn't state anything about what the plans are regarding the demolition. They could be demolishing it to put up a new plaza or to build homes. We don't know that by this document. Is that not correct?
That's correct. And in other situations, and this is kind of getting at one of the points that Councillor Morocco was raising as well, there are lots of situations where people demolish properties for lots of good reasons. There's tax reasons, there's all sorts of good reasons to demolish properties, and they don't move forward to go on to develop the property. So yes, in this particular case as well, but also in lots of other situations where this could come up as an issue. If you accept this interpretation, there are lots of reasons why people just simply demolish properties, typically for tax reasons.
So to follow up, they demolish the building and then their taxes go down the next year because there is no building on that property. And they could sit like that and find someone else to develop it, especially if they felt that they had a guarantee of reduced rates down the road. That could be used.
That could conceivably happen.
Okay.
Yes.
If there are DC charges at the city and DC charges at the region, they're rates, different rates.
That's right.
So if the city of Niagara Falls determined, you know what, we want to waive it, they could in theory say, we're going to waive our portion, and the region can say, hold on, our rules state very clearly we should be getting X amount of dollars because there hasn't been a building permit placed. Therefore, you collect what you want, but the region is owed X amount of dollars. Can that not happen?
There's kind of two answers to that question, Ms. Chen. I'm just going to take the legal aspect of it. So from a legal interpretation aspect and a jurisdiction aspect, obviously this council is charged with looking at whether or not this fits within the region's DC regime and your own interpretation. So it doesn't set a precedent value, but there's also, I think, a question that you're asking, which is more kind of the practical collection question, which I'll leave to Ms. Chen to answer.
Through the chair to the councillor, you're absolutely right. In terms of stating that the city has their rules and the region has our own rules, we're governed by separate distinct DC bylaws. So it is absolutely common that there's different DC treatment. But at the end of the day, the local area municipalities, they have to collect based on the region's rules for the regional DCs.
Okay, and a follow-up question, because the Mayor Diodati brought it up that they've done some work on that property. Wouldn't it have made sense for them, if they know what they're planning to build, to bring forward a building permit a year ago, 2 years ago, and then start working on that underground work that they were doing in the road work, et cetera? Wouldn't that be the norm for a developer?
I'd prefer not to.
Okay.
It could be.
But on the date, and just to be very clear, if they demolish on December 8, 2022, should the building permit have been placed by December 8th, 2024, or the August date that you were talking
The
about?
August date.
The August
Yeah,
date.
it's the zoning bylaw amendment application that actually triggers the timeline. So it would take you to August 9th, I believe, 2024.
And that deals with the DCs, which is different than the building permit process. The DCs that should be processed or determined at that time.
That's right. It's whether or not they can rely on the freeze. It basically says that it expires after a certain time period, and from the region's perspective, that's the August 9th, 2024 timeframe. So they're still paying DCs, they're just paying it at the normal rates.
And you made a comment, which I found interesting. Just because the province determined to shrink that timeframe to 18 months, most municipalities said, you know what, we're still going to apply it for 24 months.
Well,
You
actually,
inferred that. Is that?
no, what happened was the province, they changed it to 18 months, but because these folks had been in and had their application in by, I think it was January 2022, because they were in by that time, they were entitled to still rely on the 24 months. So the Ford government didn't say we're going to rip that away from you and 18 months and too bad for you. They still left it available for these folks to rely on the full 24 months, which is what we're referring to here.
And they were trying to speed up all kinds of building, which didn't really occur to what they wanted.
They were trying to accelerate building.
Thank
Yeah.
you.
All right, thank you, Councillor Height. We now have Councillor Reddecup.
Thank you, Chair. Thank you very much for the background information. We know that the words building permit appear in the Development Charges Act many times. Do the words demolition permit appear in the Development Charges Act at all?
I don't believe they do. No.
I think you're right. I don't think they do. They typically would appear in the development charges bylaws passed by municipalities, or in this case, the region.
Typically in relation to a credit, Councillor Reddecup, not in relation to building permit necessarily.
And I presume you're familiar with the region's development charges bylaw?
Yes.
Does that document equate a demolition permit with a building permit in any way?
Does it equate?
Yeah. Does it include, in the development charges bylaw for the region, is a demolition permit included in the definition of building permit?
No. Not that I'm
Okay.
aware of. Yeah. Yeah.
And you've indicated, I believe, and just want to confirm, the purpose of the freeze by the provincial government was to accelerate the construction of housing units. Is that correct?
That's right. It was to actually get shovels in the ground. That's the literal language that they use, which is kind of silly, but it's the truth. They wanted to accelerate development and get people moving. Yep.
And so we've heard that this particular development is proceeding. There's infrastructure being put in the ground, et cetera. But if we were to accept the proposition that a demolition permit is tantamount to a building permit for the development charges freeze, then we would have a situation where 6 months, 4 months after the passage of the zoning bylaw amendment, demolition permit is obtained, that would create the freeze, and that freeze could go on indefinitely.
That's correct.
That's the proposition, right?
That's correct.
Okay. Yeah, okay. Thank you very much for your answers.
Thank you.
All right, if there's no other speakers, I will now call on Daniel Angelucci. I apologize if I said that incorrectly, on behalf of the complainant.
Good afternoon, Chair and Regional Council, My name is Daniel Angelucci. I'm an associate lawyer at Kagan Shastri DeMello Weiner Park LLP, a very long name. I represent Cassone Dwelling BT Inc., the owner of 3770 Montrose Road in Niagara Falls. Before I begin, I want to thank you all for your time this afternoon, especially with the lovely weather that we're finally having. The materials that you have in front of you relate to my client's formal complaint under Section 20 of the DC Act. To summarize my submissions today, it is our position that the region has incorrectly determined the DCs that will be payable for the redevelopment of 3770 Montrose Road. And I'm going to begin at the end to answer a few questions that I heard from council previously. And I'm going to try to use this as well, and I'm going to hope that it works. So this is my very last slide of my presentation. These two sections say that DCs are payable upon either actual occupancy or the issuance of an occupancy permit, both of which haven't occurred yet because there's no building on site. And so when we have the question in the back of our mind, when will this be payable, and when will the city and the region collect the amounts that are owing to them under the DC Act? That will occur later in the process upon the issuance of an occupancy permit, and not today. Today is only with respect to determining what is the rate that should be used when finding out what amount is to be paid later. So as background, the redevelopment project today consists of 257 residential units, including 75 rental units. My client made their application to the city on January 26, 2022, and as part of the process of the application, the owners proactively met with municipal staff to confirm the applicable DC rates. My client had separate meetings with staff at the city as well as staff at the region. And at those meetings, our legal interpretation of the DC Act was presented to city and regional staff, namely that the DC rates applicable to this project should be those rates frozen as of January 2022. City of Niagara Falls staff reviewed and have expressly agreed with our interpretation. However, as you've heard, regional staff does not. As a result of that disagreement, we filed our complaint letter with the region on March 9th. So we submit that the applicable legal framework under Section 26.2 of the DC Act is as follows. As you can see from the DC Act excerpts that are on the screen right now, under Section 26.2 sub 1, DC rates are frozen, and I'll use that term, as of either the date of a site plan or the date of a zoning bylaw amendment application. In this case, a site plan approval application is not required for the development on the property, and so we're only going to consider subclause B, which deals with the application for a zoning bylaw amendment. I want to be clear as well, the frozen rate, there's been a discussion about an indefinite freeze. The frozen rate, the rate as of January 2022, is subject to monthly interest in accordance with the DC Act. So let's say, for instance, that the frozen rate as of January 2022 is, and I'm just going to give out a number, $10,000 per unit. It's not in this case, but let's just use that number for an example. 26.2 sub 3 says that for every month, the region and the municipality can charge interest on that rate. So to be clear, this is an indefinite freeze. This is a situation where the rate applicable in January 2022 will be subject to about 40, 50 months of interest that are increasing that number with every passing month. However, and this is where the dispute sort of kicks in order for a developer to be entitled to the frozen DC rate, the frozen DC rate plus interest, Section 26.2 sub 5, which is on the screen, states that they must obtain a permit, a building permit, within the prescribed time frame, which is, as of the time of the application, 24 months since the application was, and the last word there under 26.2 sub 5, since the application was approved. So approved, not submitted. That was in August of 2022. As I mentioned previously, the zoning bylaw amendment application was submitted in January 2022 and came into force in effect August 2022. Our client obtained a demolition permit necessary for the redevelopment of the property in December 2022, which we submit as well within the 24-month timeline set out in 26.2 sub 5 of the Act. In our submission, this permit was necessary to remove the existing structure on the lands and permit the future redevelopment that is contemplated by the zoning bylaw amendment application. As was mentioned, the dispute between my client and the region is not about the 24-month timeline under 26.2 sub 5 of the Act. The dispute relates to whether first building permit, as is used on the screen there, includes a demolition permit. And in our respectful submission, we believe that it does. You should note that 26.2 sub 5 of the Act uses the phrase first building permit issued for the development. And from a practical perspective, we submit that a demolition permit typically is the first building permit issued for a development. A development cannot proceed unless and until the existing structures, if they exist, and they do in this case, are legally removed from the property. From a practical perspective, a demolition permit must, in this instance, be considered to be the first permit for a development, or for the development, rather. From a legal perspective, and I'll move to the second slide here of my presentation. As you can see from these excerpts from the Building Code Act, throughout Section 8 of the Building Code Act, which is the section used as the basis to authorize the issuance of building permits, the term building permit is used to refer to both a permit to construct or a permit to demolish. Both are titled as building permits. I'm going to move back briefly just to the first slide here of the presentation. I'll submit to Regional Council that if the legislature wanted to be more specific to limit a first building permit only to a permit for construction, as is used in Section 8 of the Act, they could have written that limitation in to the language of subsection 26.2 sub 5. For instance, it could have said, the first building permit for construction is issued for the development. It does not use that language. Instead, it refers to the first building permit for development, which, as I mentioned previously, must include a demolition permit as a practical matter of the reality of the development process. In addition, the Ontario Land Tribunal has also recognized that a demolition permit is a first building permit in comparable contexts. I'm going to move now to the third slide of my presentation. As you can see from this excerpt from the Tribunal's decision, the Tribunal has determined in a relevant context that a demolition permit is the first step which enables a redevelopment to proceed, and as such is a building permit in respect of a development under the Planning Act. We submit that the same conclusion must also extend to the interpretation of a demolition permit under the Development Charges Act. And again, I'm going to reiterate this point again. To be clear, as of this date, my client is not asking Regional Council to order staff to issue a refund. To date, my client has not paid their development charges for this proposed redevelopment because, as I mentioned before, that will become payable at the issuance of an occupancy permit, or in the language of the Act, practical actual occupancy. There are a few matters I'd just like to briefly address in the staff report as well. So I'm going to refer to the pages of the staff report, which I hope everyone has a copy of. So on page 3 of the staff report, rather, sorry, I see now on the very top, it says page 1. So page 1, under the heading of key facts, I'm going to refer to the 4th bullet point there. It says, however, the complainant argues that the term building permit in the DC Act should be interpreted to include a demolition permit. The demolition permit that we're referring to today was issued so that development could proceed on the property. Redevelopment of any site, as I mentioned before, requires demolition to occur. And Section 8 of the Ontario Building Code Act is the only section under which a building permit or a demolition permit is issued. For the 5th bullet point under key facts, it says that our interpretation is inconsistent with the text, structure, purpose, and administrative logic of a statutory scheme, and we disagree. We believe that our interpretation is entirely consistent with the interpretation of the DC Act, which again only uses the phrase building permit and not, for instance, as I had mentioned before, limited to a building permit to construct. The intention of the freeze was to provide home builders with certainty of what development charges will be paid or what they are to be paid, and by extension, what home buyers will be required to pay. Under the DC Act, the structure is that the amount paid is the lower of the frozen rate plus interest or the rate in effect when the payment is to be made. The intention, as noted, is to ensure that the amount that is to be paid is defined at the time that the rate is frozen. I'm going to go to page 2 of the staff report now. And the first full paragraph, it says, the second full bullet point, it says, this reduction was explicitly designed to encourage developers to move from paper approvals to shovels in the ground. The reference to shovels in the ground we submit is precisely what a demolition permit entails. It requires something to actively occur on the site to allow development to proceed. Shovels in the ground for the creation of new housing, in most cases, including this cases, requires the demolition of existing structures. The same bullet point also says that the intention of the change is not to allow a permanent entitlement for stalled projects. And with respect, we disagree with this position. The project that's in front of you today is not a stalled project. It is not land banking. Our client had pulled both a demo permit and a plumbing permit before the 24-month deadline. As of right now, services are being constructed on the property to connect the future homes to water and wastewater. Roads are being built, and our client has also pulled a permit for a temporary sales office, which is on the property. In our submission, saying that this is a stalled project is incorrect. In terms of works that have occurred on the site to date, earthworks, site alteration were all completed last year. And as I had mentioned, servicing and paving is now being undertaken and expected to be completed sometime this month. Again, the project is not stalled. And just to build on this as well, you had in front of you a photograph of the issued demolition permit for the site. And I think it's important to look on that demolition permit and see the size of the building that was demolished to make way for this redevelopment. One of the permits was for a building of 4,500 square meters, and the other was for a building of 3,000 square meters. This isn't the demolition of a shed. This is a demolition of large existing structures that were previously on the property. If I go to page 3 now of staff's report, at the 4th paragraph, again, it says, our interpretation would effectively permit developers to lock in historical rates indefinitely without a clear commitment to build. As I had mentioned previously, this omits the very key provision of the Development Charges Act, which allows both the municipality and the region to charge interest on that locked-in rate for every month that passes. And so saying that it's locked in at the $10,000 amount from now until 5 years from now is incorrect. Every month there is interest accruing on that rate, which will be payable upon the issuance of an occupancy permit. The 5th paragraph on page 3 also says that our interpretation would undermine the transparency and predictability of the region's growth funding model, and we respectfully disagree. The growth funding model is based on when applications are made. At the time, the region starts to understand what services are required for the growth and to plan for it. And that is because at that time, that is when it starts to become clear as to what is actually being planned for development. And by the time that development is completed, the services have already been constructed and installed. Again, the way the Act works does not encourage vacant land to remain vacant after demolition, because as I had mentioned before, the interest continues to accrue, making it more expensive for DCs. And as an inference, that benefit gets taken away the greater that interest builds. And I apologize, I'm just shortening my submissions here for a few things that I've already mentioned. On page 7 of the staff report, under the heading C, sub I, it states that municipalities would be required to freeze DC rates at a point when no development proposal has been finalized. Again, that's incorrect. The DC rates are set and are frozen as of the time of an application being made and not at the issuance of a building permit. Under subsection C2, it says there would be an inability to calculate DCs at the time of demolition permit issuance. And again, we respectfully disagree. DCs are calculated as of the application date, and the unit rate is applied against what is constructed with the amount to be paid at occupancy. That is why we are not asking for the calculation of that amount to be set today. The demolition does not define what is being built or what is being done by the application, and that's only to be confirmed when you construct with the amount to be paid at occupancy. The third subpoint under C speaks toward retroactive reconstruction of DC liability, and again, we respectfully disagree. There is no retroactive calculation to be done. The rate is frozen as of the application. The amount is calculated using the frozen rate plus interest to the date of payment, which, as I mentioned before, is at occupancy. The municipality benefits from the interest that is calculated on that frozen rate. On page 10 of the staff report, under alternatives reviewed, the first full paragraph, it mentions that our interpretation would raise equity concerns and may also engage the bonusing prohibitions under the Municipal Act 2001. And again, we respectfully disagree. There is no bonusing, as the rate freeze plus interest is what municipalities are required and directed by the Development Charges Act to do. A bonus is when the municipality provides a reduction or an exemption that is not authorized by law or by legislation. In this case, the rate freeze is not a reduction, but the calculated rate to be applied as per the DC Act. On the last paragraph under alternatives reviewed, it also says that accepting the 2022 rates would result in a revenue shortfall for critical growth-related regional infrastructure. And again, we respectfully disagree. There's no revenue shortfall because the frozen rate still accrues interest. So to conclude my statements today, I respectfully request that the Regional Council make two determinations. One, confirm that the issuance of a December 2022 demolition permit satisfies the DC Act's requirement for the issuance of a first building permit. And two, direct regional staff to calculate our client's development charges owing in accordance with the frozen rates set in January 2022 plus interest as prescribed under 26.2 sub 3 of the Act. Thank you for your consideration of this request and for the opportunity to address Regional Council. Subject to any further questions the Chair or Council may have, those are my submissions.
Thank you. So with that, are there any questions for the complainant's representative? Start with Councillor Sorrento. Councillor Sorrento.
Sorry, Chair, I apologize. It's hard to bring up the menu. The icon's on the bottom there. My apologies. Through you to council. Question, sir, are all the units pre-sold? The proposed units?
Through the Chair, sir, I am not aware that they are. I don't believe that they are.
Fair enough. Through you, Chair, to council. Is the planner here? Is there someone that can answer that question? And if there isn't, that's fine.
Sorry, Councillor, it doesn't seem anybody here knows that answer.
Thank you. Thank you, Chair. So through you again to council, is it the applicant's intention to redevelop these subject lands and to actually build the proposed 257 dwelling units as opposed to land banking or just putting up another plaza?
Through the Chair, my client's intention is to build the development that is contemplated by the zoning bylaw amendment application. I think based on the works that have been constructed as of today on the site, including both the servicing connections and the paving for the roads, I don't believe it's fair to assert that my client wouldn't build what's set forth in the zoning bylaw amendment application. Their intention is to build what is contemplated in that application. And sir, just to reiterate as well with respect to the land banking matter, again, as I had mentioned before, even if this were to be a situation of land banking, which it is not, the DC rates still accumulate interest.
Understood, Chair. I was just trying to clarify because there was a comment that was made, and that's to you, Chair. Thank you. And through you, Chair, to council, you mentioned that there was work that was actually being done last year on the subject lands. So can you just again state very quickly what that work is, what that work was, and was it specifically so that it would be in preparation of the development of these dwelling units?
Through the Chair, Councillor, yes, the work that was done last year was site grading works, so leveling the property in certain areas to permit the construction of homes on the property in the future. Yes, the work that was undertaken under those permits was in furtherance of the development concept contemplated under the zoning bylaw amendment application.
Through the Chair to council, when did you actually start working there? Was it prior to last year? Or when did the applicant start working there?
Through the Chair, sir, our client's demolition permit was issued, as I had mentioned, in 2022. I believe works related to the demolition were undertaken in late 2022 and early 2023. I regretfully don't have those exact dates for you.
It's fine, that's okay. And Chair, through you, I just have a few more questions. What would happen should it be the will of council to deny the applicant's request tonight to adhere to the original DC charges? And I mean, the timeline to build, is there the possibility of going to OLT? I just want to know what the possible outcome could be in terms of realizing these developments eventually.
Through the chair, sir, so with respect to the first, I think the second part of your question, if, for instance, regional council were to make a decision that my client does not agree with, my client does have the opportunity to appeal that decision to the Ontario Land Tribunal. I do not have instructions on that, and so I'm not saying that they will. If that is the decision, they certainly might. That is, though, the mechanism and the structure contemplated under the Development Charges Act for there to be this hearing today with a potential appeal to the Ontario Land Tribunal if a decision is made that we feel is incorrect.
All right.
Sir, I apologize.
No, go ahead, please.
Sir, I was just going to say that if that appeal were to be taken, yes, that would ultimately mean that the development project proposed by the zoning bylaw amendment application would be effectively delayed.
Through you, Chair, to council, and if that scenario played out, the applicant would still be paying interest on a monthly basis, correct?
Through the chair, Councillor, yes, that is correct. We would still be accumulating interest on our DC rate that is frozen in accordance with 26.2 sub 3 of the Act.
Okay, so through you, Chair, part of the confusion for me is the granting bodies, Great City of Niagara Falls and then Great Region, with respect to the demolition permit being tantamount to a building permit. So through you, Chair, to council, is it your understanding and the applicant's understanding that once that demolition permit is granted, that's tantamount to a building permit?
Through the chair, sir, my submission is that a demolition permit is a building permit. As you can see under Section 8 of the Act, the language used with respect to all building permits is a permit to construct or a permit to demolish.
Okay, and Chair, and I have a final question, and thank you, and through you to council. So there's been mention that that the dwelling units haven't been built since 45 months, and that the applicant had all this time. It sounds like the applicant was actually working all along to try to meet this. So what caused the delay is my first question, and my second question on the same theme is, did you talk to Niagara Falls staff 2 years when the deadline was approaching after the 2 years, time of submission, and time that was approved?
Through the chair, sir, one of the primary reasons for the delay in this instance is that it's difficult to construct when no one is buying. With respect to the second part of your question, sir, yes, our client has met previously with both regional staff and city staff. And as was noted previously, and as I currently understand, city staff for the City of Niagara Falls agrees with our interpretation of the DC Act and the Building Code Act. And I would just add on to that as well, it's the chief building official of the City of Niagara Falls that will be issuing any future building permit.
Chair, through you, sorry, to council. So this was shortly after COVID, 2022, and we all know what happened at that time. Was it the market that changed and the fact that materials had gone up 30, 40%, and that you couldn't find skilled workers? would that be a fair assumption as to a partial cause in the delay?
Through the chair, sir, yes, that is certainly the construction costs and labor costs are certainly a factor in the financial state of a project.
Thank you, council. Thank you, Chair. I yield the floor.
Thank you, Councilor Sorrento. So now we'll move to Councilor Bateman.
Thank you, Chair. Through you, thank you for your presentation. Why did you not get a building permit instead of a demolition permit?
Through the chair, Councilor, one of the requirements of the Building Code Act with respect to the issuance of a building permit, a permit to construct in this specific instance, is compliance with applicable law. And applicable law is a very specific term. And among other things, what that requires is the payment of, the conclusion of the calculation of DCs, as well as, for instance, access to a municipal street or a private street or connection to existing municipal services like water or wastewater. You're not, an applicant wouldn't be entitled to the issuance of a building permit, for instance, if the home to be built is not connected to a road or is not connected to sewer or water.
Okay, so I guess the reason I'm asking is because under building permits, and we've already established that we believe that demolition permit does not exist in this. Is that correct? I believe that was what was stated earlier.
Through the chair, Councilor, a demolition permit was issued for the existing structures.
No, I understand that. Sorry, within this act, the Development Charges Act, did we say that a building permit or a, sorry, it's getting convoluted, I know. A building permit or a demolition permit was not in the, one of those two was not in the act, correct?
Through the chair, I'm going to point to subset or section 26.2 sub 5, I believe is the provision that you are referencing, Councillor. And again, if you look at A, the language is first building permit is issued for the development. And again, as I mentioned before, it's not restricted to a first building permit for the construction is issued for the development.
Okay, I'll move on. So you have, your client is a big developer, right? That's my research on them is they've developed quite a few homes. Is that correct?
Through a chair, they're certainly they are a developer,
Okay.
and they, I guess, comparatively are large, but as compared to the largest developers in the province, they're certainly not the largest.
No, I'm impressed. They've got a lot on the go, so I understand that. So through you, Chair, have you ever had, has your client ever had to demolish prior to building in other cases?
Through the chair, Councillor, in instances where there is an existing structure on the property that does not form part of the future redevelopment scheme, a demolition permit would always be necessary.
Okay, and in those cases, have they also got a building permit? Would you know?
Through the chair, it depends on the circumstances. Sometimes they are issued at the same time, sometimes they're not. For instance, there's a restriction in the Planning Act, and I apologize, I don't have the exact section in front of
No,
me.
it's okay.
But when you're demolishing residential land, for instance, a residential home, the Planning Act requires the issuance of a replacement building permit before the issuance of a demolition permit for the demolition of that residential property. And so in that instance, where you're demolishing residential land, which isn't the case here, when you're demolishing residential land, you need to have both a demolition permit and a construction permit. That is not the case for commercial land or industrial land or non-residential land.
So it's
So
just
in certain
residential.
circumstances, you would have both, in some you wouldn't.
Okay, thank you. I have a couple more questions. Bear with me. Can you tell us what has been approved on this site? I think Councillor Sorrento was asking, but the number of homes?
Through the chair, Yes, it's 257 residential units,
Okay.
and 75 of those 257 units are rental units.
Rental units, okay. And does the province, do you know, provide any financial incentives for these type of approvals for homes?
Through the chair, the province incentivizes both rental and non-rental development. I think that's uncontroversial to say. I don't have one of the relevant provisions on screen, but I do have one of them. So one of the provisions that isn't included in my presentation materials is that if someone is building rental units, they're entitled to a statutory discount of the DC rates that would be payable. So for instance, if you're building a 2-bedroom rental unit, the DC Act says that the municipality must, I believe it's reduce that rate by 20%. So if you're building a market rate unit to sell to someone, you'd pay 100% of the applicable DC rates. If you're building a rental unit to rent to someone, you're paying 80%, I believe, if it's a 2-bedroom rental unit of the applicable rates. So that's one of the financial incentives the province has for rental development.
Okay.
The other one is on the screen right now. In both instances, you should note that a payment of DCs is authorized on the issuance of an occupancy permit. For rental developments, it says that if you see the language, it says, shall be paid in equal annual installments beginning on the earlier date of the issuance of a building permit authorizing occupation, so an occupancy permit, and the date the building is first occupied, and continuing on the following 5 anniversaries of that date. Whereas for non-rental residential development, you have to pay in full. And so when a developer is building rental, they pay the total amount of DCs owing in 6 installments over 6 years. For non-rental development, you pay in full, you pay 100%. So that's the second financial incentive for rental that you were asking.
Yeah.
Those are the two that come to mind
Thank
with
you.
respect to
Thank you very
incentives.
much.
All right, so thank you, Councillor Bateman. We'll move to Councillor Morocco.
Thank you, Chair, and thank you, Daniel, for clarifying some points there. I just want to make this very clear. So I think really the issue that we're really discussing is the timing of them getting a permit, building permit. Because I just want to go back. They actually got the demolition permit back in 2022 through the chair. 2022, council approved the demolition. Council must have also approved, because I would have sat at some point in these council meetings as well, not in 2022, but in the gallery, that they would have had to approve the demolition because they knew what was going to be built. So obviously, they were going to be building these units. Was that not identified at the council meeting and when they were doing the demolition permit, that approval?
Through the chair. So I'm gonna take a bit of a way to get to your question, but if 26.2 sub 1 says the rates are frozen as of the date of an application, and so let's use the example I gave before of $10,000 being the applicable rate. It isn't in this instance, as I mentioned before, but let's use that number. 10,000 is the rate. 26.2 sub 5 then says your frozen rate.
Oh, no, just let me be clear. Sorry for the chair. I understand that. Where I'm trying to go is to walk through, just to get to the point. I think the point right now is that they actually have been doing the demolition. It's probably taken a couple of years because I've been by there. It's a huge project to do the demolition. So my point from the last presentation is that I was like thinking, I'm not going to support this because if they've sat there for 2 years and didn't do anything, well, shame on them. But now you've made it very clear that they have been continuously doing work on the land by prepping it for the construction of these 257 units, 75% or 75 of them are going to be
75
rental. Okay, so fast forward, there has been work. The only problem that I'm seeing right now is the timing that they didn't go and get the building permit earlier. They're just getting it now, thinking that they're always going to get a building permit because that was the plans, and that's where they're at today. So I'm kind of getting caught up on this because I'm not willing to get, and they're also going to still be paying interest on the DC charges. So the clock is ticking. No one's getting anything for free. They're just kind of froze at that point. They're going to continuously build and keep developing. So the building permit that they're asking for, have they got that now, or is it June 1st? They're actually going to get the building permit. Listen, in Niagara Falls, sometimes people just build, then they come and get the permit. I'm just being facetious, sorry.
I've never heard such a thing.
Through the chair.
Through the chair. Did I say that out loud?
Through the chair, as far as I'm aware, an application hasn't been submitted yet for the issuance of a building permit to construct. That is because the works necessary to be undertaken for the issuance of that permit have not been finalized. I named two, the road networks and the servicing connections. Those still need to be completed, and those will be completed based on what my client told me within about a month. So for the building permit to be issued, those need to be completed, and that hasn't happened yet.
Okay, through the chair. But that has been a work in process that they're trying to get to that point. So that kind of fills in the 2-year gap from 2024 to present. Is that correct?
Through the chair, yes, that is
I
correct.
need to make sure that that's it because I want to make sure that they've constantly been doing something, not just sitting there for 2 years.
Through the chair, yes, that is correct. But again, as I mentioned before, even if this was a land banking situation, which it is not, the DC rate would still be accruing interest.
Yeah. So, and through the chair, until, when you get a building permit, all developments, every developer, any time they're going to build, have to make sure 75% of the project is pre-sold. It is pre-sold. So they wouldn't be getting a building permit if it wasn't.
Through the chair, I know that some developers use 75%. I know some use higher or lower numbers, but yes, some developers require a certain amount of sales to have been completed to make the project financially viable to construct.
So through the chair, this is not a project that is sitting idle. It's been moving forward. DC charges are being paid, they're being calculated, and the interest is on it as well. And they pay that upon occupancy. So they're going to want to make sure they get this complete as quick as they can. Because if not, they're going to continue to keep paying interest on the DC charges.
Through a chair.
Through the chair.
Yes, that is correct.
All right, that's all. Thank you so much.
All right, thank you, Councilor Morocco. We'll move to Councilor Villela.
Oh, thank you. Through you, Mr. Chair. Thank you for all the additional information that you provided to us. Some things that were not mentioned previously and I think are important factors. You continuously are talking about the interest charges. Sorry, I've got like 3 screens going here, so if I'm not looking at you, I don't mean to be rude. You talk about interest charges, but I don't recall anybody mentioning what those interest charges are. Can you clarify that? Is that something that you know, or?
Through the chair, Councilor, the interest provisions for the Development Charge Act they're on the screen in the council hall. It's section 26.2 sub 3 of the DC Act, which says the municipality may charge interest on the development charge from the date the application is made to the date the development charge is payable, which, as I mentioned, is occupancy. That's 26.2 sub 3 of the Act.
Yes, sir. I'm reading that. I can see that very clearly. I guess my question is it 10%, 5%, 3%, 1.2%? Is that determined by the municipality or is that under legislation somewhere? Again, another part of, of an act that's left up to interpretation. So maybe we can be clear on that.
Through the chair, Councilor, it's not on the screen, but I have the provision in my notes here in front of me. I'm just going to look for the exact provision. So through the chair, Councilor, I regret to leave this out of the slide. I didn't think it was important for today's presentation to council, but if you see, I added an ellipsis to 26.2 sub 3. And the relevant provision that I think you're looking for is within that ellipsis. And I removed it just because it was unclear. It didn't really help towards the matter of interest, but I'll read the whole provision for council's benefit. So 26.2 sub 3 says where clause 1A or 1B applies for a zoning bylaw amendment or a site plan amendment application or site plan application, the municipality may charge interest on the development charge at a rate not exceeding the maximum interest rate determined in accordance with section 26.3 from the date the application is made to the date the development charge is payable. And so 26.2 sub 3 directs you to look at section 26.3 of the Development Charge Act. It's quite complicated. The maximum interest rate that a municipality is permitted to charge is set by statute. Municipalities may charge less, but they cannot charge more than what is set out in the maximum rate for 26.3 sub 1 of the Act. The Act is very complicated. There are 4 dates where the rate of maximum interest is changed. It can either go up or down depending on what the big banks are doing, but that is the provision that has the maximum rate that a municipality may charge.
Okay, so this isn't, my point to that is this isn't a free ride, basically. Okay, so there's interest going to be charged the longer that it sits there, or the longer that it takes. Can I ask you a question, and you can answer it or not answer it, but what do you believe the legislature means by first building permit? And I find that very interesting that they use the word first as opposed to the date the building permit is issued. They used first building permit. What do you interpret that to mean? Because that's interpretive, I guess.
Through the chair, it's my submission to council that a building permit is a permit to construct or a permit to demolish. That's the same in both my personal and professional opinion.
Okay. So then I guess this leads me to my last question. Would you say it's your position that the applicant interpreted that demolition permit as the first building permit, and therefore nothing nefarious happened here? They were just determining that that was their first building permit.
Through the chair, Councillor, yes, that is the view that our client took, and that is the view that was discussed with city staff who agreed with our view in that respect. That is also the same view that was discussed with regional staff who disagreed, and that is the reason why we are here today.
Okay, thank you very much. I think that summarizes exactly why we're here tonight. And all this is all very important, but at the end of the day, I believe it comes down to what the interpretation is here. So I don't believe there's anything nefarious on the part of the applicant or the region, for that matter. It's a matter of interpretation. So I'll leave it at that. But I just want to say thank you to the developer, because we are in great need of housing, and we are in great need of rental housing. And this council is proactive in that. So I just want to extend my gratitude for them being taking that initiative. So thank you very much.
Thank you,
Councillor. Right. Thank you, Councillor Villela. We'll go to Councillor Redicott.
Thank you, Acting Chair. Thank you, Mr. Angelucci. So it seems to me that we can agree that the purpose of the freeze was to facilitate construction of more homes more quickly. Are we agreed on that?
Through the chair, sir, yes, I would agree.
So based on your arguments, it would seem to me that there is a distinction between redevelopment of a brownfield site, which is what your client is doing, and development of a greenfield site in terms of calculating development charges. Would you agree with that?
Through the chair, Councillor, I would agree with a caveat. It really all sort of depends, greenfield and brownfield, as to whether or not, in our respectful submission, a demolition permit is issued. For instance, you may have a site where no demolition permit is necessary because there is no existing buildings on the site. And so using that as the greenfield example, this interpretation dispute wouldn't arise because no demolition permit is necessary. Using that for the brownfield example, a demolition permit would be required because there is an existing building on site. So I agree that The act is the same in both instances with respect to construction of greenfield and construction on brownfield. It's just whether or not the first building permit will be a demo permit or the first building permit will be a permit to construct. In the greenfield, the first permit will be the first permit will be a permit to construct. In the brownfield, the first permit will have to be a permit to demolish.
And in the greenfield example, you can't get a building permit until you've got all of your services in. Is that correct?
Through the chair, sir, Councillor, yes, that is correct.
So that would mean there is a benefit to trying to redevelop a site on which there is already a building, because according to your analysis, you could apply for the first building permit being a demolition permit, whereas you can't if it's a greenfield. You have to wait until you've got your services in.
Through the chair, sir, I think I think that is a fair interpretation. I would just note, though, that if you're dealing with the scenario where your DC rates aren't frozen, you're dealing with a scenario where the DC rates can be increased by a municipality year over year in accordance with the development charge background study. And so the benefit with locking in your interest rates, or sorry, your DC rates with interest, as I noted before, is that you have certainty with interest of what you can expect to pay. You don't have that same certainty, for instance, if you're unaware if DC rates will go up the next year.
Right, I understand that. And so speaking of interest, what is the amount upon which interest is accumulating in your case?
Through the chair, sir, in our case, the amount of interest, or sorry, the amount that is being charged interest is the January 2022 rate. I don't have the exact number. I know, for instance, that it's $20-something thousand. And so since today, for 45 months, that $20,000 amount is being charged monthly interest and is increasing over time.
And that's based on the position of the City of Niagara Falls that the demolition permit is the first permit for this development.
Through the chair, Councillor, yes, that is correct. You wouldn't be charged interest if your DC rate is not frozen based on the issuance of a permit.
So in this particular case, if the region's position is upheld, then there'd be no interest because the region's position is no permit has been issued in accordance with the Development Charges Act. Is that correct?
Through the chair, Councillor, I disagree. And I don't know if it's semantic or not. But again, as I had mentioned before, the DC amount that the ultimate DC amount, whatever that value is, will be payable upon occupancy. And so when an occupancy permit is issued, the frozen DC rate plus however many months of interest will be multiplied by the total number of units proposed by the development to give the region and the city the total DCs that are owing.
So what is the start date then for the interest rate? The date when the zoning bylaw amendment was approved?
Through the chair, Councillor, subsection 26.2 sub 3 of the DC Act says that interest may be charged from the date the application is made to the date the development charge is payable. So it would be accruing interest from January 2022, which is the date the zoning bylaw amendment application was submitted, to whatever date in the future when occupancy is issued. So if that were to...
I don't want to put too fine a point on this, but from January 2022 until now, what amount is interest accumulating on?
Through the chair, sir, the amount that interest is accumulating on is the per unit DC charge rate. So as I'd mentioned before, the rate as of January 2022 for the region's DCs is somewhere in the $20,000 number. I believe it's 23,000. I don't want to give that number specifically, but it's the $20,000 amount. And so for every month, that $20,000 amount is accruing interest from the date the application is made, January 2022, until the date occupancy is ultimately issued.
So your client is paying interest on units that haven't been built yet and won't be built for some time.
Through the chair, sir, yes, that is correct.
Okay, well, I don't know how that builds houses faster, but or fixes costs. Can you just put the Wellington case slide up again?
Through the chair, sir, it's on screen in the council chamber.
Right, and I can see it as well. So I haven't read, obviously, the case, but what you have highlighted tends to suggest that the court that dealt with this was trying to confine its decision to the specific facts of this case. Is that a fair understanding of what the rest of the case might say?
Through the chair, sir, yes, that is correct. It's sort of a long-standing principle of the tribunal that the tribunal's decisions have not the same precedential weight as, say, for instance, a court of appeal or the Supreme Court decision might. The tribunal's decision in any circumstance, in any appeal, is, as they always say, based on the facts that are in front of them. So again, sir, as you noted, yes, in this decision, they do mention that this interpretation was made in this case. Sir, it's our submission that we believe the tribunal would make the same determination in my client's case as well.
And so you've heard what counsel for the region has said about this case. Any comments on that, other than we disagree?
Through the chair, I don't have anything further to add to what counsel for the region had previously indicated. Our position is that this decision says that demolition permits are building permits, and they are building permits that are the first step in the redevelopment process for a given site.
Yeah, she drew the distinction between in respect of and for. You don't buy that.
Through the chair, Councillor, I understand the words in respect of and for are different, but really, as was said at the introduction of both my statements to council and my friend Ms. Morley's statement to council, the issue that in my submission is what is a building permit? And in my submission, a building permit includes a demolition permit. Whether that's a demolition permit in respect of the development or a demolition permit for the development, my position would be the same.
And just one final question, if I might, Chair, Mr. Angelucci. If interest is accumulating at a rate of $20,000 per month since January of 2022, there could come a time when it, I suppose, when it becomes financially economic to proceed with this development. You know, if you're paying $20,000 a month and there are further and further delays, we're now talking 4.5 years since the zoning bylaw amendment, there could come a time when it's no longer economically viable. Isn't that a concern?
Through the chair, Councillor, I would agree with your overall sentiment. I just want to clarify one matter, though. Interest is not accumulating at $20,000 a month. That would be extraordinarily punitive. Interest is, as I had mentioned before, under 26.3 of the Act, the way maximum interest is calculated is very specific. It's very particular. But I can give you an estimate that right now the maximum interest rate permitted by the DC Act is in the range of 5 to 6% a year. And so that $20,000 per unit amount is being charged interest at about 0.5% a month. So
on how many units altogether?
On 257 units through the chair.
Okay, and so do you know the total amount of interest that's accumulating each month? for your client?
Through the chair, sir, I don't have the specific number in front of me right now. My client has done that calculation. If you were to look at the interest, the frozen rate plus interest, as of today's date, I believe it's somewhere in the range of a per unit total of $26,000 to $28,000 per unit. And so since that January 2022 date, there's been $6,000 to $8,000 of interest that will ultimately be payable when occupancy is granted.
So my final question, sorry. So there would come a point where it may be more advantageous to your client to actually accept the current development charge as opposed to the frozen one, because presumably then you could avoid the interest that's been accumulating since January 2022.
Through the chair, sir, there's one additional provision that I would just like to put to the to the council's attention. And that is, and I'm struggling to find the exact page that I have my note on here. Sir, there is a okay, sir, so my apologies, through the chair. Section 26.2 sub 5.2 of the Development Charges Act says that the municipality in all cases must charge the lower of two rates. And that is the lower of the frozen rate plus interest, or the lower of the rate that is currently in effect as of today's date. My client's position is that the frozen rate plus interest is lower than the current rate by the municipality, and hence why we're here at this hearing today in front of Regional Council. So, sir, in the event that interest on the DC outpaces the rate that is in effect in a DC bylaw, the lower of rate becomes the effective rate.
Right, got that. Thank you very much, Mr. Angelucci. Thank you, Chair.
All right, thank you, Councillor. Are there any other further questions to staff related to the complaint? Okay, looks like I'm seeing, Councillor Kaiser, do you have your hand up?
Yes, sorry. I was just, you said to staff or is it to the delegate?
To
My
staff.
apologies.
To staff.
Oh, okay. Yeah, I just had a question in regard to one of the comments made from one of the counselors that this could be sort of appealed to LPAT, but is this not sort of a quasi judicial hearing? I'm not clear, so I just want some clarity on that.
Okay.
Through the chair, the appeal process for this specific hearing is governed by the Development Charges Act, and the appeal is available to the complainant in the event that council dismisses the appeal.
Sorry, could you repeat that? I did not understand that. I'm sorry.
The complainant has a right to appeal the decision of council today in the event that council refuses to grant the complaint and dismisses the complaint.
Yes, and who would that appeal body be? Who would they be appealing to?
Through the chair, that would be the Ontario Land Tribunal.
Okay, thanks. I just wanted some clarity on that. Many thanks.
Thank you. Councillor Encina.
Thank you, Chair. Just to comment, the whole thing is revolving around whether a demolition permit is a building permit. Regardless of anything else, anybody else is saying, whether homes are being built, whether anything else is done, that's not the issue. The issue is that was the one permit valid as the other one. That's it. Regardless if they're doing great work or not, it doesn't matter. Just one question through you, Chair, to staff. I'm not sure if you have a number on this. What is it gonna cost the taxpayer if we do this? Ballpark figure. Because it's gonna be a lot, I would suspect, and then the floodgates are gonna open. Just your interpretation of what's gonna happen, please.
Go ahead, Associate Director.
Through the chair to the counselor, so staff did a calculation to estimate the difference between the current rate versus the rate freeze plus interest, and the difference is around $120,000, which will be that is the revenue shortfall staff was referencing in the report. However, as you mentioned, this is about precedent setting in terms of whether region will be considering a demolition permit as a building permit under the DC context. So staff have been very consistent to say no to demolition as a building permit. So from a fairness and equity perspective, the developments and developer who had followed the rules, essentially we're penalizing them, and also for future developments as well. So that is, just wanted to remind council that the principal issue tonight is about whether demolition is a first building permit under the DC contact, and the revenue shortfall is secondary, I guess, in my view, for this discussion.
Thank you, Chair. That's it.
All right, thank you, Councilor Encina. So at this time, we're just going to call a recess so we can start our other meeting before the 7 o'clock deadline.
Chair, may I offer a point of procedure, if possible? Yeah. I just would, given the length of the hearing and the complexity of some of the arguments made, I would offer it for your consideration that it would be entirely appropriate to allow representatives a few minutes to make final remarks.
We're going to do that. What we're going to do is we're going to recess this meeting, start the other one, do another recess, come back to this one.
Thank you.
You want to go ahead and call the council meeting to order and then recess it.
Got it. All right. All right. So I would like to call the regular meeting of council for May 28th, 2026 to order, and I'll ask the clerk to conduct a roll call.
We're going to,
Oh, no.
we'll do that when we actually get in there. So just
Okay.
recess it.
Oh, all right. Never mind. We're not going to do the roll call. I'm just going to recess this meeting and go back to the other one. All right, so just to continue with the other meeting now, are there, once again, any further questions for staff related to the complaint? Councilor Steele, go ahead.
Thank you, Mr. Chair. I don't have a question to either of the presenters. When are we allowed to make our own comments on this? What point are we doing that?
Councilor, you may do that now.
Okay, thanks. I do disagree with staff and our legal consultant on this. This isn't a greenfield, and I think Councillor Redicott brought it up very well. If you look at what's happening, they've purchased a property, they've demolished an old Canadian Tire building, they flattened the property. Now they get a, in that process, they get a demolition permit, which is under the building permit section. It's not a building construction permit for new housing, whether it be singles, detached, apartments, whatever it may be. Then they go in and they get a permit to put their services in and put their roadways in. I don't know where staff is coming from by stating that the permit is not a building permit, because in this case, it's not greenfield, it's brownfield. The only permit they can get is a demolition permit under the Building Act, or under the building permit section of the DC charge. They can't get a construction permit until all the services and the roads are established, so that each lot has services for wastewater and for water going to it. So I don't understand when they would pull those. I'm going through this with a number of developments in Port Colborne with regards to when they're going to pull their actual, what I call construction permits of building housing. So that's what I'm confused here. And I do like the example that was brought forward with the Wellington issue, where they looked at the the demolition permit as being the first building permit. Because in this case, it is. It's the first building permit pulled, and the whole series of things go along their way till they can actually pull construction permits once lots and infrastructure is established. So I'm not going to support staff on this. I think the developer has done what he's done. He's continually building on this. I think Councillor Morocco, who lives in Niagara Falls, has made that quite clear that she sees things going on at this site. So I can't support staff on this. I think they're wrong on it. The 4 some odd million, I think it's 4.9 million is in the report, which is going to be paid on this development on 257 homes is what we should have. And I do disagree with my fellow councillors that keep saying development charges cost the taxpayer. They don't. If this guy walks away today, no development charges are paid, we don't see a dime. Development charge, we don't add money to our tax rate for development charges. And if we are, we shouldn't be. That's not how it works. So I do get upset at this because development charges should not be put on the backs of the taxpayers. That's why we pay development charges, and we want to spur development so that it helps offset costs when we want to extend services. Now, the region isn't into quite the number of services municipalities are based on fire and hockey rinks and ball fields and things like that. However, development charges do pay a lot of things for the region. But quit tying this in to state that this is going to be a boon or a detriment to the ratepayer, because it's not. But I think that they followed the proper procedure. I think that the definitions within the DC Act don't say what type of building permit. It just states building permit, because there's different ways to do this. And Councillor Redekop is correct. If this is a greenfield, their first building permit would be to construct a building. Where this one, their first building permit is to destruct a building in the demolition permit. So I'm not going to be supporting staff on this. I'm going to support the proponent, and let's get this thing moving. Thank you, Mr. Chair.
Thank you, Councillor Steele. We'll move to Councillor Sorrento.
Thank you, Chair, and I guess through you to Director Chen, and if you'll allow it, Chair, I know we're not talking about future revenue, but did staff also do a calculation of what the current property taxes are being paid at this point in time, or the portion that's being paid to the region? And then subsequent to that, once the 247 dwelling units are completed, do we know what that rate would be?
Associate Director.
Through the chair to the councillor, so there's benefits, there's overall economic benefits to the community in terms of promoting developments. Staff is in full support of the developments in housing development, understanding and appreciating that the new development will generate new assessment and help with the regions and the city's tax base. However, again, when it comes to development charges, staff have to follow the legislation, which is the Development Charges Act and the region's DC bylaw. We don't have authority to do otherwise. What the act says is there's a time frame to freeze the rate. It gives us 24 months or 18 months full close. It doesn't say that there could be an extension if there's active work going on site, and therefore staff don't have the authority to do otherwise and offer rate freeze beyond the 24-month period.
Thank you, Chair. And I'm going to respectfully submit my question wasn't answered, and I submit it respectfully, Chair. And the reasoning behind it is my esteemed councillor from Fort Erie, Councillor Encina, wanted to know what this was going to cost the ratepayer.
Well, point of order, Chair. It's Redekop. Point of order. what the taxes are in the future has nothing to do with this application.
Okay,
Chair, are we allowed to make, Chair?
go ahead, Councilor Sorrento.
Now, are you making a ruling or should I pause? What do you suggest I do?
I would actually have to agree that what Councilor Radikop has said, it really has no bearing here at this moment in time.
Okay. Now, so I'm still allowed to make comments then, yes?
Of course.
To the report. Okay. So I'm going to continue on with that. And it's unfortunate that we don't have the other numbers that we know are going to offset this $100,000. And I,
Well, Chair, point of order. You've just ruled in favor of this line being irrelevant to this application, to this matter. So I would ask that you rule that Councillor Sorrento move on to something that is relevant.
Councillor, I must agree. If we're going to continue down this road, let's not talk about dollar figures in the future whatsoever.
Could I talk about it generally without mentioning any dollars?
Don't mention any dollar figures, and I'll allow it.
At the end of the day, we're going to get a lot more coming in. And I agree with Councillor Steele and what he said, Mayor Steele. And, I can't say it any better than that. And so.
Sorry, Chair, I think, I'm very uncomfortable. Like, the point of order was called, it was ruled. It was not about money dollars. It was about the fact that Councillor Steele had already opened the door to talk about how and whether or not the opinion about how DC grants do or don't affect the taxpayer. And this is what we're still talking about. And that's what I also take issue with.
I will rule that.
What's the issue, Chair? I don't understand, Chair. I'm just making
Councillor
some closing
Sorrento,
remarks,
I'll allow you to
stating that
continue. Everybody,
I'm agreeing
calm
with
down
Mayor
and
Steele.
speak through the chair. Okay.
Through the chair, yeah.
If you're going to continue, but speak through the chair. Councillor Kaiser, I'm just going to allow him. Wrap it up, Councillor Sorrento. Thank you.
Hey, I was just agreeing with Mayor Steele, and I don't appreciate that. I think you're out of order, okay? So I don't appreciate that, Chair, and I'll just leave it at that. Thank you.
Thank you, Councillor
And I yield the floor.
All right, Councillor Diodati.
Holy mackerel.
Yeah, Chair, I have a procedural question, if I could. What's the next steps? I mean, we've heard our solicitor, we've heard the solicitor for the complaint made against the DC charge. What's the next steps? I don't think we've asked all the questions we need to ask. I don't think we need closing arguments. We got to get to a decision. When do we get to a decision, Mr. Chair? I don't know if we can ask through you, the clerk, what's the next steps before the vote?
Thank you, Councillor Diodati. I'll turn to the clerk.
Thank you, Chair. So we will have closing arguments. This is a hearing, and that's procedural fairness. And once that's done, the report recommendation, it's already put on the floor. Council will consider that and make their determination as to next steps.
So thank you, clerk. So Chair, just to be clear then, when the time comes to vote, what happens if the recommendation of staff is not successful? Then entertain an alternate motion?
Yes, Councillor.
Okay, thank you.
You're welcome. Councillor Morocco?
Sorry to prolong this. I just want to say that I am actually not going to support staff's recommendations this time. And that's very, very rare that I do that. But I think that we don't want to set a precedent, that's for sure. But I think we have to also look back to one of the situations that came our way. And we did have to look at this when I think it was, I'll say the name, sorry, La Pena, La Coco, whatever, La Pena, that came to us. And it was all about how they were zoned or whatever. And we looked at that and it was a little bit different. So they, we favored in their way. So sometimes we do have to look at applications totally independently. But this is clearly, I'm going to just say in Niagara Falls, we have a good half a dozen, holes in the ground where we have not had development go. It's tough. I understand that, and this is a development that's been working. And I actually have to say, I wasn't going to support it because I thought they haven't been doing anything, but they've actually been doing something for the last couple of years. And at the end of the day, we're not losing out on any financial. Based on what we've heard, is that they're paying interest. They're paying the DC charge, they're paying interest. And when they have occupancy, they take occupancy, they pay that. So, good. You know what? You want to take a couple of years and you take a long time to build it? Guess what? We're still making the money. And good, we'll take your money because we need it. There's no doubt about that. Was it $2.7 billion debt? So anyway, we'll take it. Anyway, I'm hoping that we actually can move forward on this and we have this opportunity for this project to be completed because they haven't stopped working. So I'm hoping that we can have the support to make this project still happen. Thank you, Chair.
Thank you, Councilor Morocco. Anyone else wish to speak?
Could we
Okay.
have a recorded vote, Chair?
We're not there yet. Yeah. We'll address that when we get there. All right. So with that, does the complainant's representative wish to provide any closing remarks?
Through the chair, sir, thank you and Regional Council for your time this evening. I won't add anything else beyond what my concluding remarks were. Again, our request today is that Regional Council direct staff to calculate the DCs that will be owing using the January 2022 frozen rates plus interest. Thank you all again for your time this evening. I don't have any further submissions. Thank you, Mr. Chair.
Thank you. So once again, now does Ms. Morley have or staff wish to provide any closing remarks?
Thank you guys so much for your time this evening. I know that this has been a very lengthy proceeding for a development charge complaint. I just want to speak to a couple of points. One is, again, just to remind you of the jurisdiction of council in this particular circumstance. This is not about weighing policy or deciding whether to grant an exemption in a particular circumstance. This is not a discretionary type exercise that's being undertaken here by council. This is a quasi-judicial decision that's being made. It is an interpretation question. Whether or not this particular developer has done things on site or moved things along, or we think that it makes sense in this particular circumstance to help these folks out by extending the 24-month period, that's not the question that's in front of you tonight. I think we can all agree. We also want to see development move forward in this province. You know, I'm trying to buy a house too. This is not about these particular circumstances. The question is, and it's the only question that is relevant to the task at hand, is whether or not a building permit is a demolition permit for the purposes of the ending the freeze rate charge. That's it. That's the only question that's in front of you. And for that, I'm just going to submit to you, I'm going to remind you of the actual language of the Act for the development. The specific case that was relied on by my friend looked at that specific language, and it said, the OLT specifically opined on this and said that that language is different than the language that was used under the Planning Act. They said that's different. It's a closer causal connection. That's about pulling building permit. That's not demolition permit. On the issue of interest, again, it's actually not relevant to your consideration today. Not at all. That's a fairness concern. That's a balancing. That's a weighing. That's not a legal question. Not at all. That being said, the interest on the rate freeze is for the sole purpose of offsetting the rising cost of infrastructure for you and for everybody else who's paying for that infrastructure. It is not intended to make up the shortfall, and if you apply this interpretation, you do so generally. There is no middle ground. This is going to be applied generally within this municipality. That's the risk that we're trying to avoid here. That's why this is important, and that's why you've been unfortunately required to sit here and listen to us now for, 2.5 hours. So those are really my only submissions on this point. Unless staff has anything else to say, those are my submissions.
Thank you. All right, so with that, council has heard the submissions and the staff recommendation has been properly moved and seconded. Is there any further discussion? Councilor Campion?
Yeah, I was waiting for this opportunity to speak. The lawyers have made it very clear. It's just a decision, are we going to take a demolition permit and classify that as a building permit? I understand there's two sides to this equation, and these two sides are represented by legal representation here, but also by municipalities. The region has one interpretation, and the city of Niagara Falls has a different interpretation. It's very difficult to determine which one is correct, and I think that's why we got off topic and started talking about interest and repercussions and all these other things that are completely irrelevant to this decision. I have been convinced that it is, by both arguments, I still am convinced that a demolition permit is a building permit in the sense that it has to happen for the building to occur. When we talk about the first building permit, in the particular case, like a brownfield like this, it is the first permit that you have to get. So I'm going to support not supporting the staff position. So I will vote against this that's on the floor right now. I also want to say that if there's a discrepancy between this level of government and the area municipalities, I tend to side with the area municipality because it's their municipality this is happening in. I know it's happening in the region, but the experience, the expertise, the dedication, et cetera, of the staff and the council within the area municipality, I think takes precedence. Not saying that we're wrong at this level, but if we have to pick one or the other, and you have a belief in what you think is right, and if there's a tipping point, I think the tipping point would be to go with the area municipality, in this case Niagara Falls, because they are in charge of what's happening within their municipality. So I'm going to leave it at that. So we'll vote against this, and I'm hoping that we will then be able to approve a different motion after this. So thank you. Those are my comments. Thanks, Chair.
Thank you, Councilor Campion. We'll now go to Councilor Secord.
Thank you, Mr. Chair. I feel like I'm chasing my tail because I keep thinking I'm going to change my mind on my initial thinking. I know exactly what a building permit is because I've got, through the years, hundreds of them. I know what a demolition permit is, and I know what the legal document is that I'm reading. The thing that hasn't come up is that where the site is now. Because I'm guilty, I should have got in my car and drove to Niagara Falls to drive by, and I didn't. But I understand there's roads and sewers in. If there's roads and sewers in, that means there was permits to put those roads and sewers in. So if there was permits, when were they issued? I don't think council's getting the whole picture, both financially, whether that matters or not, or whether this development and what was the initial date of a permit. Because wait a second, never mind the building permit, how far after the building permit did they follow up with a road sewer line permit for all of that? Was it a week later, or was it a year later, or what was it? So I'm really confused. I don't think we've got the right answer. I don't want to vote on this now because I don't think we've been, neither one of the councils that came up here mentioned anything about it. In fact, one councilor didn't know what was being done and what wasn't. So I don't know if our staff can answer that, but I'd like to know where they are in the development and what other permits were issued, because somebody had the question about permits. Well, you get permits in series because there's different things you do. There's a whole slew of different buildings. There are townhouses. Each one of those, if you've ever been in a building department and you see somebody walk in from a development, they walk in and they plunk a set of drawings and permit applications about this high, and the guy behind the counter scratches his head because, oh boy, here we go. And a development like that drives those kind of permits and questions. So can somebody from our staff tell me, are there other permits that were issued on this property? Because this is the crux of where we're going to try and help these people get this development done, but in a fair way that the development charges are imposed correctly.
All right, I'll go to Associate Director Chen.
Through the chair to the counselor, so staff have made every effort to connect with city staff to understand the status of the project. To staff's understanding, the project is still going through planning approvals. The subdivision agreement is to be finalized and executed at this point of time. And my understanding is that that will be executed in the next a few weeks. And then after that, there's further steps in the planning development process they have to go through before they can actually apply for a foundation permit, which will be considered the first building permit for this development. So again, the Region's DC process administration is that a building permit, a first building permit, is a foundation permit, a shell permit, a conditional permit, or the first full building permit to construct the building. And that's where we have full certainty of the unit mix and the development type. All the details will be confirmed at that time. When all the planning approvals are achieved and agreements are executed and registered, that's when we have full certainty that development is moving forward, the building is moving forward. So that's when we calculate development charges. That's not the case for this development. They're still going through planning approvals, and therefore staff don't have all the details and certainties to calculate DCs, which is why we don't think they have a building permit.
Okay, so I'm getting
sir.
conflicting information, because if there's work been done at the site and you don't even have planning approvals, I'm confused.
Okay, back to the Associate Director.
Through the chair to the council, so regarding the servicing, so underground water, wastewater, sewer, catch basin and manholes, that work that the complainant is saying that the work is ongoing, that's under the site servicing permits. That's also, again, not, my understanding that was issued end of 2025, also after the 24-month time limit. Again, the 24 months elapsed in August 2024. The site servicing permit was issued in December 2025.
Okay, so what you're saying to me is that development like this comes along, they do a demolition. The demolition is, the building's gone, now we have a vacant piece of property. They can go ahead and put catch basins in and storm drains and water lines and whatever other servicing they need to do without the approvals and without a building permit for a building, correct? So the developer is spending money on a grid or a design that they have that they've probably come to the city for pre-cons to go through and make sure this is what we're planning on doing. And the final planning stages are just tweaking, little things like hedges or whatever else you're doing on a site plan at the end. But the people are moving the project ahead and spending money, correct?
That is correct. But also I would like to remind Councillor that when it comes to calculations of development charges, again, it ties to the actual construction building permit. So agree with you that they are spending occurring cost to get the site ready. However, when staff are calculating development charges, we can only look at the time of the actual building permit issuance.
So that is even more key, which makes me switch my thinking again. Because now you can't assess the development charges until you know exactly what you're building. If you're building the Taj Mahal and it's gonna have gold and whatever else, and it's twice the price of this, that means the development charges are gonna be twice, correct? Okay, this is probably the most confusing meeting I've sat in all my years of doing this. I've sat through public meetings before, and anyway, thank you. I don't know where I'm going on this.
Thank you, Councilor Secord. Councilor Diodati.
Thank you, Chair. I'm just going to boil it down to really simple. It's becoming kind of a Seinfeld episode here. I mean, it's a simple question of, is a demolition permit a part of the building permit process? The Development Charges Act doesn't define the building permit under the Ontario Building Code Act. A building and a demolition permit are treated the same under Section 8. And if you want to boil it down to really simple layman terms, you have to demolish before you can build. This is all semantics. I'm ready for the vote, Chair, whenever we're ready to go, and absolutely need a recorded vote on this one. Thank you.
All right, thank you, Councilor Diodati. Once again, any further discussion? If not, I guess we're going to go to a recorded vote.
Thank you, Chair. Councillor Badaway.
Can we be clear? Voting against this means we're going to be able to bring back another motion. Is that right? I want to be clear.
Through the chair, if this motion is defeated, then another motion can be brought forward. Yes.
Okay, thank you very much.
Just a point of order, though, would that motion have to come forward at a council meeting, not in this tribunal?
No, this is a hearing,
Is it a
so
hearing?
just as we've done many of them before, an alternate motion can be put forward.
Wasn't
if
done in
this
a
is
separate
defeated.
meeting? Okay,
No,
thank you for the
same
clarification.
Councillor Badaway. No. Councillor Bateman.
Support.
Councillor Campion.
No?
Councillor Kiokio.
Opposed.
Councillor Crater.
Opposed.
Councillor Diodati.
Opposed?
Councillor Easton. Councillor Foster.
Opposed.
Councillor Gannan. Councillor Greenwood. Councillor Height. Councillor Encina.
Yes.
Councillor Kaiser.
In favor.
Councillor Morocco.
Opposed.
Councillor Olson. Councillor Redicott.
Yes.
Councillor Rigby.
Opposed.
Councillor Seaborn.
Opposed.
Councillor Secord.
Opposed.
Councillor Sorrento.
No.
Councillor Steele.
Opposed?
Councillor Villela.
Opposed.
Councillor Whalen.
No.
Councillor Zalepa.
Yes.
The motion is defeated, Chair.
All right, so the motion was defeated.
Chair?
Councilor Diodati, go ahead.
Yeah, I'd like to, if I could, introduce an alternate motion that we direct staff to calculate the DC rates as of the date of the rezoning application and to apply interest on that frozen rate in accordance with the Development Charges Act.
Okay, Councilor Diodati, I'm told that staff has an alternate motion for you on the screen. Let us know.
Okay, I'm sure yours is much better and been wordsmithed. So that's wonderful. Thank you.
All right, so you're okay with that? Then we'll just need a seconder for the motion. Councilor Campion? Okay, so then any discussion on the motion? No, doesn't look like it. All right. All right, seeing there's no speakers, then I will call the vote. Recorded vote, okay, recorded vote's been called.
Counselor Badaway. Counselor Bateman.
No.
Counselor Campion.
Yes.
Counselor Kiokio.
In favor.
Counselor Crater.
Support.
Counselor Diodati.
In favor?
Counselor Easton. Counselor Foster.
In favor?
Counselor Gannan. Counselor Greenwood. In favor. Counselor Height. In favor. Counselor Encina.
No.
Counselor Kaiser.
Opposed.
Counselor Morocco.
Yes.
Counselor Olson. Support. Counselor Redicott.
No.
Counselor Rigby. In favor. Counselor Seaborn.
Support.
Counselor Secord. Support. Counselor Sorrento.
Absolutely.
Counselor Steele.
Yes.
Counselor Valella.
In favor.
Counselor Whalen.
Yes.
Counselor Zalepa.
No.
The motion is carried.
All right, so the motion was carried. All right, so that concludes the public hearing dealing with the development charges complaint filed with the clerk under Section 20 of the Development Charges Act 1997. We are going to move into the bylaw to adopt and ratify. Going to get it up on the screen. Just for the proceeding. Just need a motion to adopt and ratify. All right, so we just need a mover and seconder for the bylaw. Counselor Greenwood, Counselor Foster, thank you. Okay, any discussion? Seeing none, then I'll just call the vote. Please vote electronically. All right, so that is carried, and there being no further business, this meeting is now adjourned. We're going to take a 20-minute recess and come back to regular council at 7:47.